What happens if you get reported for copyright infringement, but it isn't actually copyright infringement and is rather someone just trying to hurt your brand? Let's talk to everybody's favorite IP and entertainment lawyer, Tony, to find out
My
more.
name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that's dedicated to all things intellectual property.
Tony, something we're seeing more and more on social media is false reports of copyright infringement because a person is upset with another person. So if you are being falsely reported for copyright infringement on your content repeatedly, what then happens?
So there are, I think, a lot of routes to take here. I'll start with the one that I always tell everybody, which is to not panic. I think it's very, very easy to get very worked up over a potential takedown. And, let's use YouTube as an example. Takedown on YouTube means instantaneously you lose monetization. If your account is being monetized, you lose views. It could affect sort of like your algorithm, if you will, the amount of views that you'll get from your subscribers and whatnot. So umpteen ways that could be affected. I think that going into the matter with a cool, calm, and collected head is going to help resolve things. Now, second, I would say be aware or be mindful rather, or read up on what the appeals process with a specific social media platform looks like. And I mean, read up on the terms and conditions on a website like, YouTube. They may have an FAQ about appeals. TikTok may have a whole FAQ about appeals. Same thing with Instagram and Meta. Read up on the blogs. I'm sure that there are a lot of Reddit posts and a lot of Google posts out there from people that have encountered in real time. I think not to use it as like whole reliance, but I think to learn and to educate yourself on the appeals process. And then third, I would say this is where it becomes like the actual commencement of the fight, which is when you would have to essentially assess if there was even infringement in the first place. And remember, copyright infringement takes place when there's a valid copyright that's been infringed on, and one of the exclusive rights under 106 have been violated. Those exclusive rights could vary from the reproduction right, the public display right, the derivative work right, even down to the digital transmission of audio recordings. There are 6 that are enumerated in full in the U.S. Copyright Office. So one or more could be at stake here in terms of the rights being violated. And that's something that the person who has been infringed on would have to claim. They would have to say, my derivative work right was violated for this reason. My public display right was violated for this reason. My public performance right was violated for this reason. And then in addition, the person claiming infringement must plausibly plead that the infringer had access to the original work and what they used, how they used the copyrighted work is substantially similar to your copyrighted work. So that's more of like a fact-specific type of part of the copyright analysis, copyright infringement analysis. You would have to provide that proof of the access, and the substantial similarity is something that obviously would point to how much of it is similar to the original work, the infringing work. How is the infringing work? Is it like 100% similar? Is it 90% similar? So that's going to be relative to facts and an assessment of things. Now, remember, the appeals process on a social media platform is not a court of law. There is no judge. It's probably some guy named Todd behind the computer reading your claim, more likely than not, with glasses and probably eating a salami sandwich in his mom's basement. Sorry, Todd, any Todds out there.
Sorry, Todd.
So there's that at stake here. You're dealing with someone who probably more likely than not is going off of a script, a form about copyright, and is actually not a lawyer or not in a position to really make a legal decision, more or less, about some type of infringement claim. And yes, maybe it gets escalated to like an internal legal team at YouTube or TikTok or Instagram, for example. But for the most part, the appeals process is reviewed by an engineer or someone behind the scenes at the social media site. And this is where you have to come into play and really argue this is an infringement. And you can list the reasons why. You could argue potentially that the person that is repeatedly going after you for copyright infringement probably more likely than not has registered the copyright in the U.S. Copyright Office. I could guarantee you that putting aside like the more diligent people like cinematographers, photographers, what have you, I guarantee you that they're on average 6 out of every 10 people on social media are not taking their social media videos and taking it over to the US Copyright Office and registering it. Otherwise, they would be mired in debt because every single registration of a social media video would probably add up. $50 is more or less the average registration fee for a copyrighted work, a singular copyrighted work. Imagine if you're in the business of making constantly YouTube videos or constantly TikTok videos, that number adds up a lot. Just let's say 30 videos alone, 30 videos times 50, that's $1,500 at play here.
Yeah.
So it's a lot of money. I guarantee you for that reason that you could easily, sort of find their claim defective because they can't go after you for infringement under DMCA if their work isn't even registered in the first place. But second to that, this is your prime opportunity to go after the fair use doctrine. And trust me, I've said it before, I'll say it again, fair use is the most used and abused term in all of intellectual property. I hear it constantly, all the time, ad nauseum. But if you are genuinely using someone else's copyrighted work to talk about them, to talk about a matter, to talk about a situation, and you're actively using it in a way that is transformative, meaning you do a freeze frame, you do like maybe 5 to 10 seconds, and then you comment, any which way you do it, that is something that you could take to and apply in your appeal form and say, this is fair use because, and then you can sort of cite the reasons of how it's transformative, how you're providing a commentary, and that would authentically give you a fair use argument. Now that said, I think it's worth providing the disclaimer that no one factor or no one situation is similar. I'm not providing a cookie cutter model that is going to universally apply to everyone. Every situation will be fact specific. So, act with discretion, act with due diligence, do your research. And if you feel like you did, do something that was infringement worthy, where you didn't provide a valid commentary, where you didn't do anything that was transformative, yeah, you're probably going to lose that claim. But if you authentically did provide that commentary, if you did provide something that would be deemed transformative fair use, that's when you probably have a better argument to stand on. But then the second disclaimer is worth mentioning is if at any point you have any shadow of a doubt of how this process works, if you need more knowledge about fair use, if you need more knowledge about copyright infringement, if you really just lack the legal aptitude to assess the situation, that's when you go to a lawyer and you ask for their help. Go to a copyright lawyer who specializes maybe in social media content, who has knowledge of takedown notices, who has knowledge of the DMCA generally speaking, and having them help you with the appeal, with the walking through the entire process, that could help you kind of get to across the finish line and be able to get a decision that hopefully would work in your favor. But again, that's something that I would caution to anybody who feels fearful of taking the action upon themselves, or more importantly, would rather have a professional help walk them through the whole matter, especially if they have a bit of a more unique scenario than the average person that gets a DMCA takedown.
Now let's talk about the flip side of this. If someone is actively reporting and reporting and reporting, and none of these things are actually copyright infringement, what might happen to that person?
I mean, if they start crying wolf, I'm sure that there's going to be some type of violation that could go, against them in the terms and conditions of the account that the social media site where they signed up for. I think at some point it becomes more harassment and abusive in nature, and that's the kind of thing where these social media sites literally have a zero tolerance policy for, and that's relative to scenarios some scenarios where it's blatantly abuse or harassment. They won't bat an eyelash to, but something that's a bit more benign is something they'll say, oh, harassment, and that could be, that could lead to an account termination of some sort or suspension even. Now, in this scenario, I think that this is pretty evident. If you actively are in the business of just becoming a copyright troll for no reason, and you're just doing DMCA takedown after DMCA takedown over and over, and it leads to nothing, I think at some point your account lands on the eyes of a lot of internal people at YouTube or Instagram or TikTok, and they may take a hard look at your account and they may strike you. There may be, let's say, a shadow ban. They may flag your account, may suspend certain privileges, whatever it is. It may come up, or it could even lead to an account termination. And I think that the rule here is sort of like they're trying to nip in the bud sort of an abuse of power. And I think that's something that's part of the regulation of a social media site. They're trying to create a positive community. They're trying to create an environment that allows all creators to put their best foot forward and provide content. And if there is a scenario where you are authentically using someone else's copyrighted work in a manner that does satisfy fair use, then and you're trying to inhibit that behavior, that is stifling creativity in every way. But if you are ripping someone off blatantly, like you're playing the entire Super Mario Brothers movie on TikTok Live while you're playing Minecraft, I'm sorry, guy, but that is not fair use. That is blatantly copyright infringement. You're showing a movie that you do not have the license to show on a platform like TikTok Live. That could lead to an account termination. So I think that it's going to be variable specific. It's going to vary on the circumstances, but I would say odds are you're probably going to see some type of suspension, maybe even a takedown, some type of flag from the social media site.
And if you have questions on this, it is important to speak to your lawyer. They're going to be able to help guide you through this process. But if you've got other questions, you can drop those for Tony. He's coming back for upcoming episodes. And as always, you can reach out to Tony on his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor. You can check out my entertainment law podcast called Scene, with new episodes dropping every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Drop your questions down below. Tony's coming back for upcoming episodes, and we're dropping daily videos to help you navigate the world of entrepreneurship to make this your most profitable and most stress-free year ever. We'll see you in the upcoming episodes.